Hello again. We'll continue on justifying circumstances and circumstances which exempt from criminal liability. Now, Chapter 2 of the revised penal code under Article 11 until Article 15 is the circumstances which could affect the criminal liability, the punishment, and the consequences of the act of relating to or in relation to commission of a crime. That's 5. That's justifying, exempting, mitigating, aggravating, and alternating or alternative circumstances. We'll first discuss justifying circumstances. Now, justifying circumstances, you must know that there is a crime committed. The crime committed is in consummated stage, or the crime is, as you simply state, that the crime is already committed, but because of the presence of these circumstances, the actor or the person committing it will not be in core criminal liability, or will not be liable for such action. Why? Why is he not liable under justifying circumstances? Well, the reason for the rule is that the basis for these circumstances is lack of criminal intent. If you remember, actus non facitum nisi mens rea, that means mens rea, or criminal intent. When there is no criminal intent, or the mind is not criminal, or the act does not make the doer guilty unless his mind is guilty. Now, he did not intend to commit the crime, but only he acted under the following circumstances provided by the rule, or provided by Article 11. Now, first circumstances is self-defense, or defense of stranger, or defense of relative. That's the first paragraph. Self-defense. Anyone who acts in defense of his person's of rights, or rights, personal rights, property rights, provided that the following circumstances concur or present. First, there is unlawful aggression. Second, there is reasonable necessity of the means employed to prevent or repel it. And third, lack of sufficient provocation on the part of the person defending himself. That's the basic of self-defense, or defense of right. Now, lawful aggression. The unlawful aggression must come from the victim. Of course, he initiated. If it is a bodily harm, he initiated the act which would cause bodily harm. And second, reasonable necessity of the means employed. So if, say for example, he was carrying a knife and you wanted to prevent him to cause bodily harm to you, you shot him. Would that be justifying? You could argue that the means employed was not unreasonable. Well, if the attacker or the aggressor is carrying a knife, you could you could find a reasonable necessity of means, or you could find any means that could prevent the attack, because that is considered killing a knife could cause fatal injury. Fatal? Yes, fatal injury. Now, lack of sufficient provocation on the part of the person defending himself. The person defending himself did not provoke the aggressor. Just did not provoke or incite the aggressor to attack the person defending himself. That's the third element. Now, the second paragraph deals about defense of relatives. It provides that anyone who acts in defense of personal rights of his spouse, ascendants, descendants, legitimate, natural, or adopted brothers or sisters, or of his relatives by an affinity in sin degree, by consanguinity or affinity, provided that the first and second requisites in self-defense are present, and that further, in case the provocation was given by the person attacked, the one making the defense had no part therein. So, if you're defending relative or your spouse, ascendants, or descendants, any relatives, brothers and sisters, or brother-in-law, sister-in-law, the first and second requisites of self-defense must be present, and further, the third requisite is that even though the person attacked is the one who gave provocation to the attacker, the person defending him should not or had no participation in such provocation. Otherwise, you will or you cannot successfully argue or defend or state the claim of self-defense or defense of relative. The third is a defense of stranger. Now, first and second requisites are still required in self-defense. That's unlawful aggression and the reasonable necessity of means employed to prevent or repel the attack. And third is that the person defending be not be induced by revenge, resentment, or other evil motive. So it was just by mere accident, or the person defending should be happen to be in the exact time and place where he should have defended, or he is able to defend the stranger. If he is induced by revenge, or resentment, or any other motive, he cannot successfully lay out the defense of stranger. So first, self-defense. The first requisite is unlawful aggression, reasonable necessity of the means employed to prevent or repel the attack, and lack of sufficient provocation on the part of the person defending himself. And then with regard to defense of relative, the person, or first and second requisite of self-defense should be present, and further requisite will be that the person, in case the provocation was given to the person attacked, the person defending should not or had no part in that provocation. Defense of stranger, the same. First and second requisite must be present, and that the person defending be not induced by revenge, resentment, or any other evil motive. We'll continue later on paragraph 4, 5, 6 of the justifying circumstance.